The format for tonight's event, as always, will consist of remarks by Mr. Turow, followed by questions from the audience. We ask that you use the microphones at either side of the courtroom so that everyone can hear your questions. We're also very pleased to have with us tonight Mr. Nick Littlefield, who will be introducing Mr. Turow. A graduate of Harvard College and the University of Pennsylvania Law School, Mr. Littlefield served as an assistant U.S. attorney for the Southern District of New York from 1972 to 1976. From 1978 to 1981, he was the chief counsel for the Massachusetts Anti-Corruption Commission, or Ward Commission, which uncovered systemic corruption in the awarding of state and local government contracts. Since 1976, he has been a lecturer at the Harvard Law School, teaching the government lawyer, criminal and civil law enforcement, while also directing the trial advocacy workshop. A partner at the Boston law firm of Foley, Hoag, and Elliott, his expertise is in litigation, particularly white-collar criminal defense. I am pleased to introduce Mr. Nick Littlefield.
Thank you very much, David. Scott, I'm standing in front of you, but I guess that's the way it is. You want to move over one? Then they can see you.
I wouldn't want to miss a word.
Yeah. It seems to me when one thinks of Scott Turow and Harvard Law School together, one finds at least two strands that are rare and unusual, but really shouldn't be. First, I often think when I think about legal education, with its emphasis on rationality and logic within rules, that it's the antithesis of the work of an artist, of the work of a person who is creating something out of his or her imagination with no rules or boundaries. Yet it seems to me Scott, in addition to being a very successful novelist, is a wonderful writer. And I had two very brief passages, one from 1L, where he's describing his torts teacher. This is early in the year, so he may have different views. This is October and November. There may be more at the end. But as he says, with the realization that I was not missing some clear solution to all of the problems, Zekman's class suddenly has begun to make sense. I now see him as a sort of jeweler of ideas. He uses his questions like a goldsmith's hammer, working the concepts down to an incredible fineness and shine. Pretty good, I think. And then from Presumed Innocent, which he wrote on the train back and forth from home to work at the U.S. Attorney's Office in Chicago, his description of a courtroom. This is a bit longer, but I'll go quickly. In the hallway outside two enormous central courtrooms, there is a churning mass like my imaginings of the crushed poor in the steerage bowels of the old ocean-going vessels. Mothers and girlfriends and brothers are here weeping and crying out over the young men detained in the granite lockup that abuts the courtroom. Lawyers of a kind move about, hustling clients in the subverted tones of scalpers, while the state defenders shout out the names of persons whom they have never met and whom they will be defending in a moment. The prosecutors are shouting too, searching for each of the arresting officers on a dozen cases, hoping to enhance the slender knowledge provided by police reports, prepared in a deliberately elliptical fashion, the better to hinder cross-examination. Inside the vaulted courtroom, with its red marble pillars and oaken buttresses and straight-backed pews, the tumult continues, a persistent din. Situated closer to the front so they will not fail to hear their cases called, prosecutors and defense lawyers haggle amiably over prospective plea bargains. Beside the judge's bench, 6 or 7 attorneys are clustered around the docket clerk, handing in appearance forms, examining court files, and urging the clerk to pass their case forward to be called next. The cops, most of them, are lined up in pairs against the grimy walls, many of them in from the 12 to 8 shift for the bail hearings on their nighttime collars, sipping coffee and rolling on the balls of their feet to keep themselves awake. And far to one side of the courtroom, there is a continuing clamor from the lockup, where defendants in custody await their appearance, 1 or 2 of them inevitably shouting obscenities at the bailiffs or their attorneys, complaining about the cramped conditions back there and the indecent odors from the commode. The rest moan occasionally or bang on the bars. It's pretty good. So for any of you with an artistic inclination, music, acting, dance, poetry, drama, I hope you'll take it as an example from Scott. You can still do it. Don't let Harvard beat it out of you. Now, the second thing that's unusual about Scott is his legal career since he got out of Harvard Law School. 90% of you, whether to pay off bills or because you're subtly programmed by forces you're not really aware of at law school, or because you think you need it for the training because that's the only place you can get good training, will start your careers in big corporate law firms. Well, Scott launched his career in the U.S. Attorney's Office in Chicago. He started here and took the trial advocacy workshop, worked his second summer in the U.S. Attorney's Office. He knew even then that wasn't going to start in a firm. Took the Introduction to Advocacy criminal prosecution course in the spring of his senior year, and then went straight to the U.S. Attorney's Office in Chicago, where he worked for 7 years, tried 30 or 40 jury trials, handled some of the most important cases in Chicago, including the prosecution of the sitting Attorney General for tax fraud and a sitting circuit court judge for extortion, racketeering, mail fraud, and soliciting $200,000 in bribes, Judge Holzer, convicted by Scott, 18 years in prison, one of the most important cases in Chicago history and part of that remarkable Operation Greylord, which was one of the most successful undercover operations, which showed the corruption in the Chicago court system. And really, those prosecutions rooted it out. Now, and I'm glad to tell you, Scott has ended up a partner in a big law firm 8 years later. And you see, he did it and he avoided those first few years. And actually, Scott, what I wish for you now is that you have a successful law practice, that you write another novel, which will, after less than a year in print, have over 3.3 million copies in distribution, as Presumed Innocent does, and that you ultimately return to the public sector to practice your law there again. Now, Scott, I think you're among friends, and I'd just like to see if you really are. How many of you have read 1L? That's pretty good. How many have read Presumed Innocent? Yeah, I think there are a lot of people out there who know you probably a lot better than you think, Scott.
Well, I have to thank Nick Littlefield and David Van Cleve for their introductions. Nick managed to seize upon probably my favorite passage from Presumed Innocent, which I often read when I am talking in Chicago, and I do it to still the occasional critics in Chicago who say that I should have openly acknowledged Chicago as the setting for Presumed Innocent. And the reason that I don't do that is because of that passage in part, which probably composed itself in my mind while I was still in my last year here. And because the scene that I am describing is the one that I confronted while I was in the trial advocacy program and working in the Suffolk County DA's office, and that really is a description of the Boston Municipal Court. I mean, you can go down there and look at it. It very much is that way. I'm pleased to be here, pleased to be invited to address the law school forum. I must say that there is a certain resonance to me in standing here. I think anybody who's read 1L knows that I was a regular attendee of these sessions. I met Jimmy Carter here, for example, amid a throng of 18 who never heard of this Georgia peanut farmer, and I, of course, went back to write in my journal and at least was honest enough to publish my prediction that this Georgia peanut farmer could never become president of the United States. Probably the forum occasion that I remember best was the one that occurred in the spring of my 2L year. At that time, the fact that I had written 1L was still a secret from all but my closest friends. And at that time in the spring, a young man who at that time was probably the most popular entertainer in the United States, Chevy Chase, was coming to address the Harvard Law School Forum. And Chevy and I shared a unique bond. His father, Ned Chase, was the editor of 1L and the man who had commissioned the writing of the book. And so Ned decided, with his usual sense of panache, that this would be a perfect occasion to announce publicly that this book was going to be published, and who better to do it than Chevy? And so I had this, terribly forbidding sense that evening. I knew it was going to be a big deal, and TV was going to be there. And my wife Annette and I went off to our favorite meal in Cambridge, the then named Charlie's Beef and Beer, and we went to Charlie's and had a wonderful meal. And although I'm thrilled by the turnout tonight, I assure you that it is nothing compared to what Chevy Chase drew. There were people all the way back to Harvard Square lined up out of this building. And of course, here I am, my great moment in the sun is about to come, and I can't get into the building. So I found one of my classmates who had queued up early, and I went running up to him, and I said, "I've written this novel, and it's a big secret, and Chevy Chase's father is my editor, and you just got to let me in." And displaying the acute training that Harvard Law School provides, he looked at me and said, "That story is too ridiculous not to be true." And he turned and gave up his place in line and let me in. And I must say I'm embarrassed to confess that 10 years later I can't remember who it was, but whoever it was a great act of kindness. And Chevy made his announcement in his own fashion. And 1L went on to do what it did, and I went on in the fashion that Nick has already described. Coming back here, I thought I would take the occasion to give you my own reflections on some of the issues that 1L raised. There is a preface in 1L where I say, no doubt I would write a different book 10 years later, and indeed I would. And I must admit, I see Professor Sanders sitting here, who was one of my teachers, and so I kind of gulp as I do this, because I think it may violate some rule of proportionality to be complaining about anything a decade later. But notwithstanding that, I do have some continuing complaints with legal education that have largely been sharpened by my years in practice. To really explain my complaint with law school, I have to sort of talk for a bit about the profession and my own view of it as I've experienced it in 10 years as a practicing lawyer. On the one hand, I think that being a lawyer in 1988, one is a participant in what is probably the single most dominant institution at the moment in American life. Law and lawyers are really in their heyday. Not only are their incomes huge, at least in the sector in which I now practice and in which many of you are going to practice, but more important probably, the influence of law in the United States at the moment is extraordinary. One need look no further than the television ratings to see the kind of extraordinary attraction and curiosity most Americans have for the law. And I think as you look deeper, you see that many of the kinds of societal issues that were once reserved from the law as matters that were too intimate, too private, are now matters of legal debate, ranging from things like AIDS or gender and racial discrimination, but abortion. Most of our moral crises tend to get resolved in the legal forum at the moment, and obviously that was not the case when the Republic was founded with its nearly theocratic base. So there is that exciting element to being a lawyer, and yet, in spite of that, I think when you talk to lay people and inspect the public opinion polls, you find that whatever the view of the law as an institution, lawyers themselves are often despised. Just tracking that socially, that goes back, I think, to the Watergate era, when people first recognized in the United States that lawyers and law schools seemed to promote a kind of misconduct that they were not prepared for from people who were supposedly educated in principle. And one of the more interesting phenomena to me of this disregard for lawyers a few weeks ago. I was with a group of friends. Actually, it was my Indian princess troupe, to be honest. I take my daughter on various campouts, and as happens when these groups are particularly successful, the fathers all like one another. And we all are in different callings, and there are a few lawyers and more people who aren't lawyers. Well, we were out one night, a few beers, and we were at somebody's home, and as we're leaving, the non-lawyers all stood around and told lawyer jokes, which apparently have, supplanted ethnic humor as the best one. The one I like best, and I hope I don't blow it, is there's a doctor, an engineer, and a lawyer standing around, and they're debating whether or not God was a member of their profession. And the doctor says, well, it's clear that God had to have been a doctor, because anyone who's delivered a baby and seen that perfect form knows that God had to have been a physician. And the engineer says, no, he says it's clear that God, who created the world out of chaos and darkness with such perfect order, had to have been an engineer. And the lawyer says, no, you're both wrong. It's clear that he was a lawyer because he created chaos and darkness first. Whatever the reality that those kinds of jokes mask, there is real hostility to lawyers, and it hardly behooves me to pretend that I do not understand the source of that. My experience as a prosecutor, in particular, exposed me to what I sometimes refer to as a kind of proctologist view of the legal profession. Most of the people I prosecuted, because of the nature of the assignments that I had, were attorneys, and I prosecuted, as Nick mentioned, the sitting Attorney General of the state of Illinois. I prosecuted lawyers for not paying their taxes. I prosecuted lawyers for selling narcotics. I prosecuted lawyers for bribing judges. I saw a lot of very bad behavior among lawyers, and obviously it is greatly exaggerated to say that is the norm. One of the things that I like most about being in private practice is the general comity and the civility with which lawyers treat one another, and the kind of upright behavior that I frankly see on most days. And yet the fact of the matter is that if you push a lawyer and ask him whether he has witnessed misconduct in the profession, conduct that exceeds recognized ethical limits, or even sometimes the limits of law, most lawyers will confess to having seen it, and to having seen it often. One of the things that probably signals, and it is often true, is that lawyers don't like one another. That's part of what I sometimes refer to as the legal malaise. There is, and I'm sure many of you are familiar with it, a kind of unhappiness that sometimes sets in among some practitioners years on into the practice. And it may be midlife crisis, but it usually expresses itself as a kind of gilded cage phenomenon in which people will talk to you about the fact that they're very well paid and very well respected and not very happy. And when you push and try to figure out the reasons for that, part of it is, as I'm sure those of you who are preparing for practice know, it is very hard. It is not an easy life in most instances, especially in the large firms to which most of you are heading. And I must say, as an assistant United States attorney, I worked every bit as hard as I work now in private practice. And it is in some a kind of stressed out existence in which you're always racing deadlines. There are combative opponents. There are clients who are sometimes never satisfied. There are partners or senior colleagues who seem to have no end to the demands that they want satisfied. And it is, like many other jobs, it is very hard. And that certainly is part of the legal malaise. But to me, I think that what I find people disturbed about most often when I really push them, and I tend to remember one conversation when I make this point, is there is a sense often among lawyers that they're not doing anybody any good, and I mean that in the capital G sense. They tend to see themselves as involved in various commercial wars, handing money between one side or another, and they don't see the social utility of what they are doing or their service to any scheme of larger ideals. And to me, that comment's always solidified by one of the better-known commercial litigators in Chicago, who, while I was an assistant United States attorney, kind of closed the door, and he had a terrific gleam in his eye talking to me about my job. And he said, "Oh, you've got the greatest job. It's the greatest job in the world." He says, "This job is terrible. What do I care whether his robber baron wins or mine?" And the distinction that a lot of practicing lawyers labor with, and I must say this is a term I first heard from Gary Bello while I was here, is this sense of doing well rather than doing good, a sense of being tied to a culture of professional competence that does not really admit of any kind of idealistic content. And I must say, and this is where I segue back to where I began, in my own mind, that dichotomy between doing good and doing well begins to arise in the law schools. And it begins to arise in the first year of law school, where people often report this sense of feeling carried away, taken away from themselves by the kind of assault of legal education. And what people learn in law schools, and in part it is an understandable desire on the part of the faculty to avoid the political debates about the values that underlie different legal rules. But perhaps in service to that, perhaps to avoid that, professors end up teaching students it doesn't matter what the argument is as long as you make it well, as long as it's persuasive, as long as it is convincing, as long as you can always think of the counter. That's a good lawyer. A good lawyer is someone who can always argue appropriately. And I see that divide between doing well and doing good really comes to inflict itself on the practice. Some lawyers become subsumed in that culture of doing well, which translates itself often to how much money are you making, and to some extent I think feeds the misconduct that takes place among lawyers, and that there are others who are gripped by this malaise. What can law school do to abate somewhat those problems? And I must say, in offering these remarks, I don't believe that there are any panaceas, but I do believe that the profession belongs much more at the center of legal education than it is presently. Most lawyers have never had the experience in law school of thinking deeply about what the profession is concerned with. I think it is probably the corniest thing some of you have ever heard said, and yet, after practicing law for 10 years, I continue to believe that as lawyers you are fundamentally involved with the process of doing and determining justice. And even in environments where people don't often think that is the case, that really is what is going on. The lawyering process and the lawyering profession really is engaged in finding just and equitable solutions in situations of conflict. And there really is a good to that. There is a kind of nobility to that. And I came to recognize that, I think, while I was an assistant U.S. attorney. I found my initial years as an assistant United States attorney extremely frustrating. The defendants were always, to me, obviously guilty, and it was so hard to prove that. And there were various factors that disappointed me. I found it very frustrating to see the extent to which the ability to communicate or not communicate with a jury so obviously quickly changed the results. I was concerned about judicial deference. Whatever the existing inequalities in the system before trial begins, once you get there, the fact of the matter is there's only one side that can appeal. And I saw judges who I thought were not particularly defense-oriented when it came to sentencing or came to pretrial rulings, but when it came to the conduct of the trial, they knew that the defendant had the ability to get them reversed and the prosecutor did not, and so they deferred repeatedly to the defendant. And I was seething with this. And yet, as time went on and I tried more and more cases, I began to recognize that there were certain implicit values in that system, that it was important that a system that was ultimately going to impose often terrible forms of tangible punishment have a quality of lenity to it. Even though I thought the truth-seeking process was somewhat distorted in the courtroom, I realized that really was not, finding out what happened was not the game. The idea was to see if the provable facts could be contorted in any way into a shape that was somehow consistent with innocence. And miraculously, as the years went on, I suddenly began to feel, hey, I could be a defense lawyer. And indeed that is what I do now, at least for part of my time. The problem, as I see it with law schools right now, most legal education, is it does not put the profession at the center. It does not get students involved with the fundamental issues of practice, which really are being, on one hand, a determined advocate who will put his own values aside within the limits of law and ethics. And who must always deal with a kind of dialectic between what the legal system demands and what the client needs. Those are the fundamental conflicts of practice, and law school really does very little to address those things. And when I say this, of course, the common response is, look, law school is not trade school, and I am not trying to turn law school into trade school. I am not calling for a Red Guard revolution in which all law professors would now become legal file clerks, the better to understand the minutiae of a lawyer's day. But I look at things, we always study in law schools judicial opinions. Rarely, if ever, do you turn around and look at the briefs that the practicing lawyers filed. You always look, you seldom look at the remedy when you're studying law. You're always looking at the grand structure, and yet remedies are what practicing lawyers are inevitably concerned with. And of course, the reason I think that the practice occupies so little attention is because, by and large, law professors don't want to practice. They have, for different reasons, decided not to spend their time as a practitioner. Obviously, there's a financial sacrifice for almost all of them in doing that, and obviously there's a certain, I'm sure, nobility and good intention in the choices that they make. And yet, what they do in the law schools is to create a world very much in their own image. It is the legal world is really not, the law school world is not a world where, whatever the catchphrase, you learn to think like a lawyer. The game at Harvard Law School when I was here was to learn to think like a law professor. And that means that the values of the law professor's world remain at the center. Legal scholarship, the law review, are the important things of the icons of the law school world, not the values of practice. And I always had the sense while I was here that the select few would go out and become law professors, and that was good, and the rest of us were plowmen who would go out and practice law. And yet, that whether professors intend that or not, the extent to which they disparage practice begins that process in which students do not recognize the real good that they are doing as practicing lawyers. And the profession, as I said before, belongs, in my view, much more at the center of this educational process. The jurisprudence of the adversary system needs to be studied. I'm not talking about a pure 3 years of clinical education, the sociology of the law, notions of what constitutes fair and unfair arguments. I don't think I ever heard a professor say, gee, you think that's a fair argument, in the sense of just understanding how argumentation ought to proceed within the limits of common understanding. And obviously, ethical questions are fundamental to the practicing lawyer's life and deserve to be much more thoroughly considered in the law schools than they are presently. And in calling for, in admiring the lawyering process, I suppose that I am likely to be criticized for as a sort of apologist for especially the corporate legal world, in saying that there is a kind of nobility, maybe even a moral imperative, in being somebody's unhesitating representative. I may be charged with some degree of fairness with trying to tell you all to become a cadre of happy hired guns who will go out and pile the dollars high while you represent various detestable causes. And I think my response to that is to say that the legal system is not that blind. You may represent the detestable causes, you may delay justice, but it will not be denied. I think the bigger concern to me about the hired gun mentality is the extent to which it does not recognize the limits that exist. You have to be prepared, if you're going to represent the detestable causes, to lose. And you have to be prepared to lose within the professional limits that exist. Legal ethics, again, I do not think are yet solidly enough established in the curriculum. It's impossible, for example, to teach civil procedure as practitioners experience it without looking at the incredible dominance that ethical questions almost always play. The most frequently cited rule of the Federal Rules of Civil Procedure in my practice, to the extent that I do civil work, and in the discussions I hear, are not discovery rules, they aren't class action rules. It's Rule 11, which is the rule that says that you can't file false pleadings. And the constant tension between impassioned advocacy and the limits that the profession has provided is a commonplace of the practicing lawyer's life. And it is not something that the law schools either make you much aware of or teach you to deal with. And it certainly, the classic ethical dilemma is the dilemma of client perjury. The man is on trial for his life, for murder, and he wants to lie about what happened. These are not easy questions. I know what the answers are. I've read Nix versus Whiteside, and I know what the Supreme Court has said, and I must say I compliment the Supreme Court for at least dealing with this issue, because for many years ethical questions had no place even in our court decisions. But it's still a very, very complex issue, and I remember standing with a defense lawyer in Chicago who I have great feeling for, who explained to me he was representing a black alderman in Chicago, a leader in his community, who was on trial for extortion, and he was ultimately convicted. And this lawyer happens to be a friend of mine, and he was telling me about how he had to decide what his client was going to testify to. And he was, I don't think, aware that he was in sharing this with me, confessing to what was probably a federal offense. But he was an impassioned advocate who understood how much this trial meant to this particular man, whose life truly, in a sense, ended with the jury's verdict. These are extremely difficult questions. One of the secrets I'll let you in on is that these rules, like all the other rules you learn about, do not have finite boundaries. They are complex questions. They can be infinitely debated, but they do represent in themselves a conception of the profession. And they can't be shuttled off to a 2-hour course that everybody has been required to take only, by the way, since 1973. This curriculum that you endure was formed long ago without any component that included professional responsibility and education about that. Anyway, I've probably said enough. There is obviously, I think, an argument to be made that the lawyering process does not accomplish any of the worthy goals that I ascribe to it. And I frankly think that since many law professors have chosen not to practice, either quietly or overtly, they may hold those views. But I think that if there is a debate to be had about what the profession accomplishes, it belongs out front. It belongs during these years of your life, because you are. This is the common ground that you will have in this profession. This is where your sense of mutual enterprise, to the extent it exists, will be nurtured. And it is important, I think, that you leave here recognizing what you are about as lawyers, and my advice to you is to feel good about it. You are on the way to doing something that, for all its incredible complexities and deficiencies, is good and worthwhile. Thank you.
Any questions? Please use the microphones if you have any questions for Mr. Turow.
Stillness. Silence. God, I saw law professors who weren't able to do this.
Hi.
Hello.
First of all, I just have a complaint that I always wanted to tell you personally since earlier on this year. You made me waste a whole Sunday afternoon that I could have been doing law stuff, trying to figure out what happened in Presumed Innocent, not able to leave until I finished the book. So I'm not going to be happy until I told you that face to face.
Thank you very much.
Another question that I have is, what's on a lot of our minds is, of course, the amazing thing that with all of this legal practice and all the many hours you had to put in, you also produced a best-selling novel that's on both bestseller lists now. And the question that a lot of us have is, how do you do it? I think a lot of us future lawyers and even some future authors that may be out here tonight would like to know, how do you juggle two professional interests?
Well, the secret of how I finished Presumed Innocent really revolves around my wife, Annette, who is herself an artist and is always sneaking in an hour or two with now 3 children upstairs, drawing, painting, and I was early in 1986, and I'd been working on Presumed Innocent on the commuter train and on vacations. And I was in the midst of the trial of Judge Holzer that Nick mentioned, and who was convicted, as Nick mentioned, of mail fraud while that was still a crime. And It was a very intense experience for me. This was a celebrated trial, one that I had put a tremendous amount of myself into in terms of the investigation and then the trial itself. And I got into this phase that I often get into when I'm on trial, 3, 4 in the morning. I snap awake and then I roll back and forth. And inevitably, my wife is awakened by this. And one evening or morning, she finally propped herself on one elbow and spoke to me the words that I think are familiar to the spouses of trial lawyers everywhere. And she said, "I want you to quit that goddamn job." And Annette's idea was that when the Holzer jury went out, I should go out the other door and not come back. And I was having at that time 2 young children, not courageous enough to do that. But what I did is I carved out a gap of time between my departure from the government and my entry into private practice. And so I had 3 months in which I was not a lawyer at all, in which I finished presumed innocent. How, over the long term, I will now balance my revived writing career with the very great demands of a legal practice is something that I wrestle with every day. And sometimes I turn to my partners and I ask them what to do. But I would like to remain a practicing lawyer, and I would like to have time to write. And as I say, it really is kind of a daily, it's a daily struggle. Right now I get up at 6 in the morning and I write till about 8, and then I go and I work as a lawyer the rest of the day. That's not all. It doesn't always seem to be a completely satisfactory alternative, but we'll see what the future holds.
I have a question I've wanted to ask you for about 3 years now. Who were your first-year law professors?
Well, that'll provoke another story. I'll answer that question straight. I had Lou Sargentich for torts. I had Duncan Kennedy for contracts. I had Arthur Miller for civil procedure. I had Jim Vorenberg for criminal law. I had Charlie Haar for property. And I had Phil Hyman for a law and public policy course. Now, I have always refrained from identifying publicly who was who, and it is not an untruth when I say that I went and I observed other sections during the course of the year, and I have always said that the characters, that no character in 1L represents any one person, including professors. I consider them persons too. Now, Professor Miller was not, he was apparently not convinced by that, and he proclaimed, I remember in the Harvard Law School record, that he was the model for Perini, and I refuse to this day to make any comment on that, but his best response occurred at the end of the first term of my third year. I was a 3L when 1L came out, and one of my friends came running to me, and he was in Professor Miller's copyright course, and Professor Miller had given an exam which had the following question on it. You are an associate in a large law firm. Your senior partner introduces you to his dear friend and client, Rudolph Perini. Rudolph Perini has had the unfortunate experience of having a student, Ray Ripoff, write a book about him. Please advise Professor Perini as to what causes of action he has against Ray Ripoff. Other questions? Yes, sir.
You said at some point while you were working as a prosecutor, you suddenly realized, or seriously realized, hey, I could
Well, to take the second question first, I do not see any conflict between the way I think as a lawyer and the way I think as a writer. I think, there's not that kind of dichotomy in me. There is a tremendous dichotomy in the terms of address. If you pick up Presumed Innocent and you read, just a line or two, you recognize that there's a much different vocabulary there. There's a much different worldview and a much different voice that is speaking there. But obviously, both the kind of gray flannel voice of the lawyer and the voice of Presumed Innocent are voices that reside within me. And I've never felt that the lawyer was going to kill off, the creative parts. That's just not a concern I had. And to that extent, I was very lucky in that I did not go directly to law school. I spent a number of years as first a writing fellow and then a writing instructor at Stanford. Now, as to the other question of this transition, I think there were a couple of things that were significant to me. One was that I slowly became disabused of the notion that in being a prosecutor, even in the United States Attorney's Office in Chicago, for which I still have the fondest and greatest regards, although they are often my opponents now, I've lost the notion that I was always doing the right thing. The fact of the matter is that there were the kinds of inhibitions I described before, and that it really was important to be, first of all, a competent lawyer, and that I began to get acculturated and recognize that, the highest form of compliment one often paid, but the highest form of compliment one lawyer can pay to another is to say he or she is a good lawyer. So I recognize the value of competence and the fact that I could do well but not always do good, that I could not control juries, I could not control judges. I think, though, that to me the one thing that really proved to be the worm that turned was recognizing that the witnesses that the government called were not providing unswerving versions of what had happened in the past. And that even though I would cajole and beat on these people and yell and scream, various kinds of self-interest led them to mitigate their own version of what they themselves were responsible for, the desire to conceal the role of friends, and I was shocked. I was in about my third or fourth year as an assistant U.S. attorney, and I was trying a case with a much senior prosecutor. And the defense lawyer came in and says, "Look, my guy is just not going to plead guilty." And my friend said, "Why not?" He said, "Well, your witnesses just don't have it quite right. That's not just the exact way it happened." My friend said, "Oh, the government never gets it exactly right. We're always a little bit off center. Is he guilty or isn't he guilty?" And that was a jolt. It was a jolt to me, that concession. And realizing that there was a job to do, that there were that the truth was not apportioned exclusively to one side, and also recognizing what I said before, that there is a kind of nobility in being the unhesitating champion within certain limits of law and ethics, especially to people who are in many ways despised, just led me to feel that this was a role that I could comfortably occupy, and I have comfortably occupied it. I really have. I enjoy being a defense lawyer. I enjoy my civil practice as well, but I enjoy doing combat with the government. It's frustrating, and it's hard to be in the dark, but I like the role.
I've been wanting to ask you this for a long time, too. I think you made generations of Harvard law students really anxiety-ridden about being a 1L. And what I want to ask you is, was it really that different 10 years ago, or is your perspective just not representative? I mean...
Well, I think there are two kinds of responses to that. One is the place may be a little bit different. The other thing is that I never made any warranties that I'm like everybody else. I am an anxiety-ridden creature, and I always have been. I still am. Probably a little less so than while I was a 1L. All I can say, though, is I didn't make anything up. I mean, my internal experience is my own. Did my particular section go nuts over outlines at the end of the first year? Yeah, that's exactly what happened. There's no concealing that. And by the way, that is not something that has not happened at Harvard Law School in the last few years. Now, it may well be the case that some sections are better than others, and maybe my section was particularly bad that year, and maybe things haven't changed at all, except for the peculiarities of that experience. But yes, my section did rise up in revolt against one of our professors, and yes, there was an article in the Boston Globe about the way the students had protested that teacher's teaching methods, and there was this kind of frenzy, and I guess I was lucky that I had that kind of fodder to write about.
Did you really not have time to see the movie until March?
I think that, that probably is accurate. Now, you have to bear in mind, there's one kicker, which is I was writing a book while I was busy being a first-year law student. And for those people who don't write books while they're first-year law students may have time for a movie before March. But
your portrayal is presumed innocent, and the portrayal receives based on quantified planning of the American criminal justice system. Speaks a lot to the feeling I think a lot of law students have about getting into that area of the law. What would you say as a former AUSA to encourage someone to either prosecute or defend within the system and not to go into private practice?
Well, I wouldn't give up those years for anything. I think it's an extraordinary environment. You deal every day with acute questions of right and wrong, profound kinds of conflicts, victims with a sense of terrible outrage and hurt who've been done often real harm, and this contrasting desire on the part of the society not to imprison the innocent. And it's an extraordinary experience, obviously colorful, full of remarkable characters, and certainly there's probably no place in the world this side of a racetrack where you meet and see more interesting types. But I remain in Nick's camp on this one. I really think some period of public service is well advised. My partners would probably kill me for saying this, but they know very well how I feel. And if you want to learn to try a lawsuit, you're not going to learn in most big law firms, because those responsibilities go to the senior people and who've had years to learn how to do it. And you're not going to get the same kinds of experiences or the same kinds of responsibilities. So, I say do it. Both my book and Wolf's are sometimes credited with putting forth a kind of unsavory portrait of the criminal justice system. And I must say that, and I'm sure Nick would say the same thing, that to some extent the federal system is removed from some of the most colorful aspects of the state court systems, and may be preferable for that reason and may not be. But overall, it's not an accident that the outcome is as it should be of Rusty Savage's trial. I mean, that is the way I see it, warts and all. And it in a very gross, approximate way, it does what it's supposed to do. So.
Back to 1L.
Sure.
As I'm sure you're aware, many law students, not just at this law school, but all across the country, almost view that as required reading either before or during the first year. And I've got a two-part question related to that. First is it correct, is the rumor mill correct when it says that you actually had the contract for that book lined up before you started here at the law school?
The short answer is yes. I was in my fourth year out of college, and I had finished a novel. Rejection slips were flying back to me for that novel, and I had decided to go to law school, and I wrote my agent a note saying, I'm going to go to law school, and almost as an apology, just to kind of give her something to compensate for my defection to the legal world. I said, if you know a young person, it would really be a good idea for somebody to write a book about law school, because I can't find anything that's written from the student's point of view. And it was kind of symptomatic of my communications with that person who was then representing me. I had never suggested that I wanted to do it, but I went to the mailbox one day and found a contract there to write the book that became 1L, and so I signed it.
Okay. Since you think that not enough attention is paid to ethics, why don't you comment on the ethical impact of the fact that you knew while you were writing the diary that this was part of preparation for a book, as opposed to many people who keep a diary and then subsequently use that as material for a book?
Well, I suppose you're always dealing with the kind of Heisenberg uncertainty principle of whether the observer will affect the observed. I told my closest friends what I was up to at different points in the year, but they all knew before the year was over. My classmates in large did not. My professors did not. I remember Dean Sachs asking me if he could read the manuscript before the book came out, and I remember answering no. I'm not sure that I recognize the ethical dimension. I understand that people did not realize that they were being observed, and certainly, except to the extent that people chose to identify themselves and choose to identify themselves years later, I made efforts to preserve their privacy. But I also thought that it was an experience that was worth reflection and scrutiny. And I don't see much difference between keeping the diary and writing the book afterwards, and knowing in advance that the book was going to come out. Well, I think that people who thought that they had been well portrayed thought it was a distinguished work of literature, and people who didn't find the portraits particularly flattering thought that it lacked something in substance and merit. Well, I'm, typically superstitious, and I don't talk about what I'm working on. So, except to say it's about lawyers and families, I have little to say about the new novel. As far as the genesis of Presumed Innocent is concerned, when I got to the U.S. Attorney's Office, I began nurturing again this dream that had brought me first to Stanford of being a novelist. And so I began thinking about writing a novel about this exciting, turbulent, emotionally involving criminal justice system. I also had in mind the words of a senior partner at one of Chicago's large firms who had. I was standing around in a group having cocktails during that wining and dining phase in the 2L summer, and somebody said, "Oh, you're going to write a book about. Now you're going to go to work for a law firm and write a book about that." And this senior partner looked at me and said, with not much trace of humor, "That'll be the last job you get." So I had that in mind, and I figured, one more episode of Kiss and Tell, and I was done. as a lawyer. And so what recurred to me was the experience I had had when, as a 3L, I decided it was a good idea to absent myself from the campus in the hurly-burly that surrounded the publication of 1L, and I worked down at the Boston, at the Suffolk County District Attorney's Office. And I must confess that if you look closely at the setting of Presumed Innocent, and if you look at what was going on in 1978 here in Boston, you will see certain resemblances. For example, in Presumed Innocent, Raymond Horgan, the grizzled veteran district prosecuting attorney, is running against a younger, more vigorous lawyer who has left his office, having been catapulted to public attention by his efforts to prosecute a black doctor who's committed abortions. And of course, what was going on in Boston during the time that I worked in the Suffolk County DA's office was that Newman Flanagan, a man a good deal older than Raymond Horgan, was running against Garrett Byrne, who's a good deal older, the grizzled veteran district attorney, was running against Newman Flanagan, a former veteran of his office who had catapulted himself into public attention by attempting to prosecute and prosecuting Dr. Kenneth Edelin for abortions that Dr. Edelin had performed. And so you can begin to see some of the congruence and where some of the material came from. What was hard about Presumed Innocent was not the initial elements, many of which, frankly, do hail from my time in the Suffolk County DA's office, but really figuring out the plot. And I did spend 2 years where I just stopped writing, trying to figure out the answer to the question of who done it. And I finally reached my decision and then reasoned backwards. So. Yes, sir.
What do you think of the Chicago method of teaching
I didn't like the way I saw it utilized in the most bullying fashion. I don't see any need for that, for a professor to, prove that he can dominate 150 brilliant young people. And I must say that I really see what goes on and continues to go on in certain classrooms here as being largely an exercise in ego without a necessary pedagogical end. But that's not so much the method as the individuals who are using it. It can obviously be very, very gently employed. During my second year here, I was taught by a man named Marvin Sherlstein, who was a professor at Yale, who was visiting, and he was the most gentle Socratic interrogator you've ever seen, to the extent that if students answered questions incorrectly, he would hit himself on the side of the head and say, "What a dumb question! How could I have asked a question that dumb?" And so, I mean, to some extent, it depends on the hands of the interrogator. I am also disturbed, though, by the continuing use at this law school of classes as large as they are here. I just think that really forecloses the kind of education, of give and take with the faculty that really would be beneficial. People learn anyway, and I think that's due largely to the fact of who they are when they walk through the doors. It's an extraordinary group of people, a remarkable assemblage, and bright enough to teach themselves and bright enough to teach one another, and that's what takes place here. Frank?
Not a question I'm asking on my own behalf, but since your teachers were Duncan Kennedy and Lou Sargent, I'm a little curious what your thoughts are about critical legal studies, because much of your emphasis in your talk, or at least one side of it, was on need for more emphasis on justice and so on, which is a high claim of the critical legal studies people, and I wonder, I was a little surprised when you made no mention of
actually, like most speakers, I was skipping around in my notes. My view of, I am not an expert on critical legal studies. I played with the folks from the forum with whom I had dinner, one of my favorite parlor games of looking at a group of law students and say, can somebody please explain what critical legal studies is to me? And actually, I think I got a fairly good answer from Barbara, although it was a brief one. I think, from my perspective, the critical legal scholars are as guilty as everybody else on the law school faculty of doing what I accused all of you of doing, which is that critical legal scholars want to teach you to become critical legal scholars. They are not any more interested in the practice and the needs of the profession than anybody else. I mean, for example, were I someone who made pretensions to being influenced by Michel Foucault, to me, the paramount question to be asked right now about the practice of law is what is happening to the quality of reasoning in the era of the Xerox machine and the word processor? What happens when, we're up to 850 f-second, when the law is multiplying so fast that no one, be he professor or certainly not practitioner, can be an expert in it? And I think that the critical legal scholars are as guilty of not taking the profession as a starting point of inquiry as anybody else. They have their own hobby horse to ride. So.
Are you aware of the program on the legal profession here at Harvard Law School?
Well, I can't claim comprehensive knowledge. No.
It did seek to address the concerns.
Well, I compliment the law school for that. Thank you all.